I'm going to tell you, like on our end, let's say you're going through a custody case and, there's a DUI that pops up. I will tell you, we start off with, we go to the clerk site, we get the records, we get the probable cause, affidavits, police reports, tickets, anything in the file. We find the agency. If it's the sheriff's office or highway patrol, we're going to do a public records request. We're going to want the footage, the videos, the body cams, the whole thing. We try to get all that evidence off the bat. And if it appears that the person has got a history of drinking, it's not a one off thing, then that may be enough to still bring it up in the custody case. If the kids are involved, there's a definite nexus between the behavior and the children. That's going to make it concrete that we got a problem. We're going to probably be raising, various motions. A lot of people are still really not aware of this, that Florida is now for child custody, the presumption's equal time sharing, 50-50. The judge is supposed to still weigh all of the factors in 6113, all the best interest factors for the kids that are spelled out. But I will tell you, I think while there is no super factor according to the law or to the statute, substance abuse and domestic violence seem to be the ones that really move it off the 50-50 presumption the fastest. In those cases, you're going to see the body cam footage. You're probably going to have DUI trial number two. And a lot of times, what happens in the family law case, if someone like Joe is representing you and the criminal case is not over, but we get to family law court first, I normally, if you're my client and you've had the DUI allegation made against you, I'm going to tell you, you need to really talk to your criminal defense attorney, because if we go to court and you're asked questions about the DUI or you make statements about the DUI in court, those can be used against you and you could be waiving your Fifth Amendment right. So sometimes why this custody thing is unfolding and you want to tell your side of the story, and maybe it was a bad stop, or maybe, something else was going on and you're diabetic and that's why the machine was off, or there's all kinds of things, reasonable explanations that can explain what's going on. You may have to literally sit there quiet, not talking, because you don't want to mess up your criminal case, and then really, have a conviction, or have that, conviction used against you potentially at the final hearing. So, it's a world of entanglement. Um, the two issues become entangled. And I always tell my clients, like, depending on what you're charged with, if there's a criminal case, then the criminal case may have to take precedent over the family law case, and you may have to just invoke your right to stay silent unless you and your defense attorney decide that that's not an important for your case or your defense. But I've yet to meet a criminal defense attorney who said, "No, please go to court and talk about it." It's normally, like you said off the bat, be quiet, keep your mouth shut, don't say anything. And so we're sitting there, with arrows being shot at us, and all we can do, man, at that point is cross-examine and duck and dodge, because we can't go on the offensive, and the judge can't really even hear your story without risk of, you getting trapped maybe in a bad question on cross-examination and that being used against you in the criminal case. So, um, those are real life consequences just off the first offense.